Court of Appeals is now in session.
Good morning and welcome to the Court of Appeals today. We have reconfigured the panel and we are prepared to hear arguments in the case of Knowles versus Knowles. Counsel, if you wouldn't mind, please enter your appearances for the record.
Morning, Your Honors. Julie Nelson for Appellant Dwayne Knowles.
Emily Adams for Appellee Celia Knowles.
Thank you both very much. As you are aware, we have been conducting these arguments virtually for the past little while. Both sides have 15 minutes in which to make their argument. It appears, Ms. Nelson, that you have reserved 3 minutes for rebuttal. Is that correct? We will do our best to make sure that there's no virtual problems. But if you lose volume, if all of a sudden your camera stops working while you are arguing, please, we will try and keep track. But if something goes wrong, will you please notify Ms. Collins or one of us as soon as you can, and we'll try and get it fixed and go from there. Let's see, anything else? We will keep our microphones muted if we don't have a question. If we do have a question during your argument, we'll try to get your attention, but keeping the microphones off, and if the other counsel who is not arguing can keep their microphone muted and camera off, that just helps. I think that helps with the bandwidth, and it helps with everybody being able to pay attention to the arguments that are being undertaken at that moment. Do either of you have any questions? I know you're both pretty familiar with how we've been doing this, but any questions before we proceed? Great. Then Ms. Nelson, anytime you are ready, please proceed.
Thank you, Your Honor. Before I start, I'd like to take a point of personal privilege and thank everyone for reconfiguring the court and so graciously moving the argument, including opposing counsel, graciously agreeing to move the argument after I got in a car accident, which fortunately was not worse. So thank you. I know that was somewhat inconvenient. Julie Nelson for Appellant Dwayne Knowles. I'd like to take our arguments a little bit out of order from the brief and start by talking about the present alimony order regarding the marital standard of living and specifically regarding tithing. The formula for calculating alimony in Utah is really well established. The details, the nitty-gritty can sometimes get dicey, but the big picture is very straightforward. The trial court is supposed to figure out what the parties were spending and make sure there's evidence to support that, and then figure out if there's enough money to keep them both at that level. And if there is, then that's the alimony payment. And if there isn't, then they're supposed to equalize so that each party has to tighten their belts proportionally. What the trial court is not supposed to do is go through individual line items and decide whether the parties can keep spending their money on that. This is really well laid out in Rule versus Rule. In fact, that case stands for a lot of things, but this is one of the important decisions. In that case, the trial court did what the trial court did here and anticipated that there wasn't going to be enough money to go around. But instead of, just equalizing, the trial court in Rule eliminated entirely donations, gifts, retirement, things like that. And this court reversed. In paragraph 23 of Rule, this court explains what the trial court did. And in paragraph 26 of Rule, if I can just read it, this court reversed because the trial court's decision was based upon its own determination that they were not necessary, these expenses, they were not necessary to the party's present circumstances, not because there was no credible evidence to support those expenses as part of the marital standard of living. And that is exactly what was done here incorrectly. The trial court anticipated ahead of time that the parties wouldn't be able to afford everything, and so it struck tithing, it struck donations, and the reason given was that they were not necessary. Now, I think it's important that we recognize that trial courts do strike expenses all the time, but they strike them because there's not enough evidence to support it, or because it wasn't actually part of the marital standard of living. But here, that wasn't in play. Celia never argued that the parties didn't pay tithing. Judge Harris?
So the alimony statute does use the word needs.
It does.
And so what are we supposed to make of that? Does that mean we do have some sort of role to play in assessing whether an expense is needful? I mean, we can spin some examples. Let's say a family spends $10,000 a month on playing the roulette in Wendover. or something like that. I mean, is there no limit to, we just take whatever their expenses are without any look at whether those are needful? I can't hear you.
We've lost your sound.
Yeah, I can't hear you, Miss Nelson.
Sorry.
And Ms. Adams, I don't know if you know your camera's on.
The answer to your question is that the case law does not evaluate whether expenses are discretionary. I understand the statute says needs, but the question is, what do they need to keep them at the marital standard of living, not what do they need to stay alive. If it was what do they need to stay alive, the case law would look a lot different. And Rule lays it out in paragraph 23. The trial court had entirely removed and excluded expenses it determined to be voluntary discretionary expenses, and thereby eliminated any amounts for retirement, gifts, donations, vacations, and travel and education. And I think vacations, travel, education, those are the perfect example. We could eliminate them as not being needs. And we can talk about whether tithing is a need and what happens if people don't pay their tithing. And, it's kind of a weird thing to exclude, I think. I don't think there was a religious motivation, but it's just a puzzling thing to exclude. And the case law doesn't ask us to evaluate what was necessary, or that's.
Can I ask in this way though? Here it seems like the trial court did skip a step, right? It did not consider the payer's expenses or payer's ability to provide alimony in light of the marital standard of living, right? This was an expense or a payment that this couple made regularly when they were married.
Right.
But if we remand and ask the court to make that determination, do we need to remand to ask the court to make that determination if at the end of the day the result is the same? Would it be a abuse of discretion for the court to say, well, yes, they made this payment throughout their marriage, but I find that there's just not enough money to go around, so they have to take that into account in their needs.
Well, so the result I don't think would be the same. And that's why we do need to remand, because what the trial court should have done was figured out that Dwayne's ability to pay was after he paid his tithing. And so his ability to pay was less, and that would lead to a shortfall. And then the court would need to equalize at that point. And the parties at that point both have to tighten their belts, but they get to choose what they're going to tighten their belts about, right? And it wouldn't end up with the same number. You'd end up with a different number. So yes, I think we do need a remand.
I had a similar question about whether there was harm as a result of let's assume that there's error in the process, that it should have been factored in. But because the court deducted it from both the husband's ability to pay and the wife's needs, is my understanding. Was 10% deducted from both? Then was it a wash? Would there be no impact?
That's a good question, but the amounts were different. And if we go back and look at the financial declarations and see the amounts that they paid, they're different. So the calculation would have been different. So we're looking for a couple of things here. One is we need case law saying that, yeah, you're supposed to include this. And in this case, we need to go back and look and see what it was that Dwayne had paid. Now, I understand that the court also eliminated Celia's, but Celia didn't appeal that. And so it's not clear to me that there's a pathway for relief. But in theory, if there was, then the amounts would be different. And so the ultimate alimony payment would be different. And it's important to note that this is not just permanent alimony going forward, but also temporary alimony going back, because Dwayne's ability to pay excluded tithing all the way back as well. And if there are no further questions on that, maybe I'll move to talking about the temporary orders. So the temporary orders is something that comes to us because the proffer process is so quick and dirty. And, we're not here to talk about changing the proffer process. We're here to talk about, well, what happens when that quick and dirty process turns out to be really, really off. Now, in minor, this court called it a rough cut, those temporary orders. And I think that's a great word for what the temporary orders are supposed to be. We're supposed to just kind of figure it out, and then we get to trial and we figure out what it really should be. But when we get to trial and we find out that those numbers were way off, then we need to reconcile. Now, we have case law where the trial court did reconcile and this court approves it. That happened in both Minor and Burgraff. But we also have case law in McPherson, and that's a really important case on this one. It's 2011 UT App 382, where the husband's ability to pay, Judge Harris.
Yeah, before we get into the merits of the argument, I would like to hear your response to the preservation point that Ms. Adams made in her brief.
Yeah.
I think the argument there, as I understand it, is the legal theory raised below with regard to retroactive true-up of alimony had to do with dissipation of assets and failure to work. It didn't have to do with exactly the arguments you're making on appeal. And I just wonder what your response is to that.
Right. Thank you. Sorry, I should have started with that. What you just described was an aspect that we had asked for, but we had also asked for exactly this relief. And you can see it in the objection to the commissioner's recommendation. That's at R322. And then after the trial court affirmed the commissioner's recommendation, we filed a petition for interlock. And then we raised it in our trial brief at 1043. And we raised it in closing arguments. And we raised it in a Rule 5259 motion. That's at 1200 to 1201. And in a document called Issues for Clarification at 1244. And all of those places talk about it.
Well, talk about it. I understand they talk about retroactive true-up of temporary alimony, but how do they talk about it, right? What is the legal theory that you presented, not you, I know you weren't involved. What is the legal theory that trial counsel presented to the court on this point? I mean, the point I'm getting at is if the legal theory is completely different here on appeal, we're going to have a hard time faulting the judge for, not going along with that argument. So when you say it was raised, can you drill down a little bit more on that?
Yeah, I'm looking at 1200, record 1200, which is the Rule 5259 motion. And at the bottom of 1200.10 says the court should make additional findings as to why the respondent's income imputation should not be applied retroactively. The court does not give specifics as to why respondent was not imputed income on a retroactive basis when she was able to work full time, blah, blah, blah. So the trial, it says that she had originally been imputed like $1,300 a month, and now the trial court's found she can make $1,800, $1,900 a month, whatever it is. It's a difference of $600 a month. That amount should be applied retroactively. That's one part of it, is her income. And the other part of it is her expenses. So on page 1201.11 is the court should add additional language regarding alimony arrears. The court does not make findings as to why petitioner is not entitled to a judgment for the amount of alimony that was ordered versus what has been ordered during the temporary orders. And then it gives a number, which is a little different than our calculation now, but there are explanations for that. But It goes on to say the issue of alimony arrears as of May 2017 was reserved in the first temporary orders ruling. Now, it does go on to talk about her refusing to work during the interim, but then it says, and claimed expenses that she did not even have. That was the theory at trial all along, was that she had claimed these expenses that she did not have and that Dwayne should be paid back for. Does that answer your question?
Yeah, I think so. That's helpful. I'll go check those record sites. Thank you.
Yeah. I think you'll see it in 1244 and 1043 as well.
Can I just ask a follow-up question about that? In the trial court's order, in paragraph 13A, petitioner claims $4,236 pursuant to his exhibit number 13. In that regard, he claims direct payments of $15,892, and that credit should be given to him for shared family type expenses. So are you, in this preservation, are you saying that the district court just kind of failed to acknowledge the arguments that were made at trial regarding the arrearage or the retroactive amounts that were argued for? Or did Mr. Knowles actually make specific requests to back up his request for specific request for, because the trial court found that there was nothing proved, like that the parties neither party had actually proved their requests for this retroactive amount.
I want to also point you to page 1381, paragraph 12. The trial court, it says alimony, this is the order on issues requiring clarification. It says paragraph 12, alimony arrears. The court makes no modifications to its findings and states neither party submitted sufficient evidence for arrears or overages. But our point is that there's no evidence here. Like, we're talking about a math problem. We know what the temporary orders are, and now we know what the permanent orders are. There's not evidence. It's just a subtraction issue. And so I don't know what evidence he was thinking could come in. I mean, evidence is kind of a weird word to use there. So I would say that what the trial court did was say, no, I'm not going to deal with this, but not because it wasn't raised.
But in 1354, in that same paragraph 13, but in D, the court says the parties essentially asked the court to utilize the tally sheets that they both provided to the court by way of their respective exhibits, without supporting documentation, and to infer from those items that their figures are correct. Don't we have to look at what the court thought that it was before it in terms of evidence? And what I understand is that the court said, sure, you gave me these numbers, these tally sheets, and then you told me to go back and look at them and examine them, but you didn't tell me how to do it, or you didn't tell me, basically identify for me the pertinent information from those exhibits.
Well, I think that I think this becomes an interesting question about what does preservation mean, right? We have to preserve the issue. We know he knew what the issue was. We have to preserve the legal theory. We know he knew what the legal theory was. What is it that exactly needs to be preserved? Does it need to be nailed down? And those tally sheets are hard. I agree. But the reason the tally sheets are hard is because they were incorporating a bunch of different theories simultaneously. And so, they were asking for X to be changed, and that would change Y, and that would change Z. But once everything's laid out, then we can say, look, here's the mistake. And the mistake is that we know what the temporary orders were. We know what the permanent alimony was. The trial court found she was voluntarily underemployed, and the trial court found that her expenses were lacking, artificial, and remote. Okay, well, extend that back to the temporary orders. And if we go to McPherson, we see a very similar fact pattern where this court said that it needed to be remanded and the trial court should have gone back and fixed it. There's a discretionary time and way to not do that, but they have to address it. Judge Harris, I'm sorry, I know I'm well over my time.
Yeah, I know you're over your time, but we've been peppering you with questions, so you have an excuse.
Thanks.
And I have another. To getting to the merits of the argument, now that, past preservation, it seems to me, I think everybody agrees the standard of review here is abuse of discretion, right? I think you agree with that.
I do.
Okay, so how does that come into play, right? Is the trial court imbued with discretion to refuse to true up temporary alimony in a situation like this? For instance, on the ground that, hey, the party who's holding the money right now, which would be Celia, relied on a court order, right? And now to try to order her to disgorge $62,000 is not something I think she's able to do right now. This is over a multi-year span. That money is gone, and that would visit a huge hardship on her. So I'm not going to order her to do that based on sort of equitable considerations. Or the court could say potentially, hey, the things that changed didn't change until very recently, and so I get that the final alimony is a different number than temporary alimony, but to me that doesn't result in the necessity of having to go back and do a true up. I mean, does it come down to a trial court just explaining the reasons for the exercise of its discretion? And is your complaint here that the court really didn't explain it?
Well, that was kind of a long question, so I have kind of a long answer. I hope that's all right. The first hypothetical that you offered was where, that's a lot of money to pay back. That's a little hard for me to stomach because in both Minor and Burgraff, where I was arguing the other side, I lost. And the reason that we lost was because the wife had low alimony and the trial court decided she had low temporary alimony. And the trial court decided that it was appropriate for the husband to go back and pay that. And the argument that I had made there was he's relied on this. And the trial court decided to go back and do it, which put him into arrears instantly and, change the property distribution and all of that. So it's hard for a trial lawyer to tell a client what's going to happen when it can flip-flop back and forth. So that's one part of my argument, but it wouldn't be required. I think that's what you're going to say is that
isn't that inherent in a discretionary standard of review? I mean, the trial court makes a decision, right?
Right.
And that decision could conceivably go either way as long as the trial court explains the reason for it. And
right.
if it's within its wide discretion, we affirm it whether it's this way or that way.
Right.
It seems inherent in the standard of review, right?
So that gets us to your second hypothetical, which was what if the trial court decides that things have changed? Yes. If the trial court decides that things have changed, that makes sense. But when we look at McPherson, we see a place where they explain how a trial court can abuse its discretion. And what happened there, like I said, is similar to what happened here. The temporary orders were based on husband's income at X. Husband lost his job and petitioned to modify the temporary orders. And the trial court refused on the basis that maybe he had lost his job on purpose. So then we go to trial and we have this whole evidentiary hearing, and the trial court decides, no, he didn't lose his job on purpose. He legitimately lost his job, so he can't pay that amount going forward. But it doesn't change it going back. And it comes up to the Court of Appeals, and the Court of Appeals said, once your basis for the temporary orders was eliminated, then you should have. That is the word they used. You should have done it. Now, I realize that sounds like it's not discretionary language, but I think it is in the sense that it's saying this is how you abuse your discretion when the platform that your temporary orders rest on falls out. And that's what happened here. The temporary orders were based on her having this depressed income and bloated expenses. And after trial, the trial court finally agreed with Dwayne that, yeah, she is voluntarily underreporting her ability to earn, and yeah, her expenses are bloated. But it wasn't until we'd been through an evidentiary hearing that we could see that. Now, that's why I'm saying that it's important that the trial court doesn't give a reason that it didn't go back and change the temporary orders. It just says there's not evidence. And that's where I'm saying evidence of what? There's no evidence. Like, we know what the temporary orders were. The evidence is her income was depressed, and really her income can be $1,800 or $1,900. And the evidence is that her expenses were way high, and really they're X.
So if we remand this at your request, what does the remand order say? Does it say Judge, you have to do a true up here and come up with a number? Or does it say, Judge, you need to go back and explain your reasons here. We're reviewing this for abuse of discretion, but we can't tell what your reasons were. So please go back and think about this issue a little bit more and tell us whether you're going to do a true up, and if so, why or why not.
Well, I think you have to instruct it to do it under McPherson, because I think that is the controlling fact pattern here, not the others. So McPherson tells us if the platform, if the foundation is gone, then you should have done a true up. So I think that's what this order looks like. I think that if you chose the latter, then we might be back here arguing later that, well, its reason was bad. She got all this extra money, but that extra money is an interesting point, because she gets all this extra money and Dwayne's left with not very much of his paycheck. Plus he's paying tithing, which the trial court decided he couldn't. He moved into his parents' house so that he could afford these orders. If a party in that position, if one party is incentivized to really, really bloat their financial deck, knowing that on proffer it's probably not going to be fixed later, they're incentivized to fill it up as much as you can so that your ex-husband can move into his parents' basement apartment so that you can get all this extra money. But we've petitioned for an interlock and this court declined it. We've got to have an ability to review that period. That $60,000 is a huge amount of money to these people.
But what if the court had said, the reason I'm not going to do it is because I find that she can earn, that this income should be imputed to her now. But at the time of temporary alimony, she was recently divorced, had these medical issues with her children, had been out of the workforce for a long time, her age, all of those things put together, that was an appropriate salary to impute to her at the time, and now it's changed.
That
if the court did,
that would work, but not on this record. In theory, I can see that, but on this record, it doesn't work. She had originally argued that she couldn't work because she had these kids, and the commissioner rejected that, told her that, yeah, your kids are in school full time, you can work, that's fine. And then after trial, the trial court says she's voluntarily underemployed and there's no impediments to her working, voluntarily underemployed. And it didn't give any reasons that during that period, she was correctly imputed the amount. It just said, yeah, now that I've looked at all the evidence, you're right. I agree with you. She could have been earning more money. Yes, there's a case out there that does what you say, but it's not this one.
But it seems like if we accept your argument, basically what we're saying is once all the evidence comes in at trial and they set a final alimony amount, if it's different and there's no explanation for why it should be different, the district court has to do the true up. And that seems inconsistent with the discretion that the trial court has.
Well,
how do we reconcile that?
I don't know that it is inconsistent with the discretion that the trial court has, because what we say is you have to do a true up, but you can make these decisions as to why you're not going to do it. And hopefully most of the time it's not a big difference, right? We have to balance your concern with the countervailing concern that there's no way to reconcile that temporary period. These days temporary orders are in place for years. And if they're really, really off, then that can really damage one party. So yeah, there's this mix of concerns, but there's got to be a way to straighten it out. So I think the answer is you have discretion to decide what your true up is going to be, but you have to look at it, because especially when the parties ask you to look at it, right? Like they did here. If the parties don't ask you to look at it, then I guess it's not a problem. But when they ask you to look at it, then you need to figure out why it was off and if you're going to fix it. And if the parties need to appeal that on the grounds of equity, then I guess they can.
Can I ask one more question? In McPherson, it seemed that one of the most important considerations was that Mr. McPherson had lost his job. And once after trial or at trial, once the court determined that he was not voluntarily underemployed, that he didn't, purposely get fired because he didn't want to pay his support obligations. The court found that even if the commissioner's recommendations seemed well-founded at the time of the hearing, once the premise of the decision was proved inaccurate, there was no reason basis to impose temporary support obligations that were mathematically impossible for husband to pay. Here we don't have that situation exactly, right? We might not have exactly enough money to support both parties, but we don't have a mathematically impossible situation where it's impossible for Mr. Knowles to pay. It wasn't impossible for him to make that payment. Did he want to? Was it overinflated? Maybe, but he wasn't. He was still employed and in a position where he was making the same amount of money. Is that a consideration that should be taken into account in the court's discretion to decide whether to impose a retroactive obligation?
Well, I think we need to think about what's the purpose of alimony, and is the purpose of temporary alimony different? And I don't think that it is. I think the case law suggests that the purpose is the same, and the same Jones factors should be considered. It's just that it's based on such limited, quick and dirty proffer that you don't really get to flesh it out. I mean, we could, if we didn't have that proffer system and we took a lot of evidence, then the temporary orders would not be this high at the beginning, but that just doesn't work. So, we do this rough cut so that we can get everybody through, and then we get to the end and figure out whether that was right. But if we hold the standard to be mathematically impossible, so we're saying, well, I mean, you can still eat, but you have to live in your parents' basement, or you can still eat, but you can go on lots of vacations and not have to work, and you have to work all the time and live in your parents' basement and never go on vacation. That's not consistent with putting the parties on equal footing so that they can move forward with their own lives. I don't think that alimony has ever been about mathematics. I mean, I understand your sentence. This sentence says mathematically impossible, but that's not the standard that we hold people to in regular alimony. Like, well, can you pay it? That's not the question, right? The question is that the correct amount to allow people to go forward on equal footing so that they can make a clean break and move forward with their separate lives? When it's as off as it is here, then I think we need to go back and rectify it, especially when we have these other cases that are going the other direction. I can't fathom that we have alimony rules that apply only to payees and not to payors, right? It's okay if the payor has to pay the payee extra money, but it's not okay if the payee has to pay back. That doesn't make sense. So no, I don't think mathematically impossible is the standard. That seems like at the far end of the spectrum. I will yield the time to Ms. Adams and reserve for rebuttal.
Thank you, Your Honors. Emily Adams for the FOE, Celia Knowles. I think important to this case is the standard of review. As this court has recognized, it's an abuse of discretion standard, and the court has wide discretion when deciding how to craft temporary order and alimony awards. I'd like to first start with this temporary order issue and the issue of overages. Mr. Knowles makes three arguments on appeal. The first being that Ms. Knowles' income was too low at the temporary order stage. Problem is, so the court imputed her $1,200, a little over $1,200 of income at the temporary order stage, and then imputed her $1,800 at the trial stage. That was completely appropriate under the circumstances. The Utah statute, Utah Code 78B-12-2038C, specifically allows a court, if there's a parent with no recent work history, or if their occupation is unknown, a parent may be imputed in income at the federal minimum wage for a 40-hour work week. And here, the parties don't dispute that Ms. Knowles had been essentially a stay-at-home parent for 26 and a half years. Prior to the divorce, there were 6 children. Back in 2006, she had worked for a year at Target, and I believe the record shows she made $7 or $8 an hour while she worked there, and she worked evenings. And then prior to that, she worked at a video rental store, and it was about $7 or $8 an hour. And so she just didn't have she really didn't have a work history at the time the parties got divorced. It was completely within the district court's discretion to rely on that statute and impute her income at minimum wage. It's just, and what's interesting is that when we get to the final order stage, the court does recognize that things have changed. The court does make some findings that there's a reason why the temporary orders are set at $1,200 and the final orders are set at $1,800. On record page 1345, that's the court's ruling where the court is saying the court finds that time and circumstances change. So it had been 2 years since the parties had been separated. Some of the childcare responsibilities that had weighed heavily on Ms. Knowles had changed. For example, the youngest child that had type 1 diabetes, the court specifically found that type 1 diabetes was more under control. And so a lot of the concerns that she expressed in the temporary orders phase, that she needed to be available to go to the school, to help with her diabetes and things like that, a lot of that had been ameliorated by that point. So the court does make sufficient findings. The court relied on a statute, and therefore it's not an abuse of discretion for the court to have set her income at $1,200 at the temporary order stage, and then once it had more information at the final order stage, to set it at $1,800. It simply isn't an abuse of discretion. Yes, Judge Hayden.
That's my question is even if nothing had changed in the circumstances, nothing had changed with the children or anything else, what is your response to the proposition that once they have a vocational expert who testifies that yes, she can make more than this money, if nothing else had changed about the circumstances, does the trial court have to go back and adjust the temporary alimony? Or is this just, well, there's just different evidence before the court at different times, and these are independent determinations?
Your Honor, I think they're independent determinations. Temporary orders is supposed to be a Band-Aid. It is supposed to be quick and dirty. It is not perfect. And when there are times that there are significant overpayments or underpayments, like in the McPherson case, and we'll talk about that in just a minute, there are ways that parties can remedy that. But that just isn't the situation here. Here we have...
Follow-up question. Quick follow-up question. But does the court have to explain why? Does the court have to explain why they aren't offsetting or doing a true-up?
Well, I do think that the court does need to give some reasons about why it set the temporary alimony and why it set the amount at the temporary alimony stage and why it set the amount of income or whatever at the final order stage. I do think that there needs to be explanations for why the numbers are right here and why the numbers are right at this point. But I don't think the law requires that there be an explanation about why the numbers have changed, because circumstances do change. The amount of evidence that's available to the court at each stage is different. So I don't think the court requires, I don't think the law requires, certainly the statute doesn't require that there be some sort of explanation for why the alimony or the income set at that initial stage is different than at the final order stage. And like I said, in McPherson, there are some remedies if they are different. If, for example, the court in that case made a conclusion or concluded that all of its underlying assumptions about why the husband wasn't making enough money were wrong. And if that's true, then yeah, the court needs to be changing its temporary alimony. But that simply isn't the situation here. If we move to the expenses part, what's really interesting is that on record page 1515, the commissioner had a binder full of documentation supporting Ms. Knowles' expenses at trial. And of course, that binder isn't here on the record that I am aware of, and there just hasn't been any allegation that any of those expenses were wrong. So we had support at that temporary order hearing that supported all of these claims for expenses. What's also really interesting is that we have the accountant said that the parties were spending $8,000 a month. Mr. Knowles was bringing home about a little over $9,000 a month, and the marital living expenses were about $8,000 a month. So it's not out of the realm of possibility that when Ms. Knowles filed her financial declaration that she was looking at their marital expenses and saying, yeah, we spent about $8,000 a month. What's also really interesting is that we do have documentation going through that Ms. Knowles was using these things, the things that the district court ultimately took off, the chiropractor, the vitamins, the therapeutic massages, all of those. There was evidence that, she testified at trial that she used them. For the chiropractor on page 2032, she said, yeah, I used a chiropractor during the marriage. That's what I did. On page 2032, she also talked about how she spent that amount of money for vitamins. And for therapeutic massages on page 2041, she said that was also incurred during the marriage. What's very interesting is Mr. Knowles testified likewise. He said on page 2181 of the record that he spent money on vitamins and supplements, but he didn't put that as a line item in his financial declaration because he didn't think it would be wise. On also page 2181 to 2182, he said that he used therapeutic massages during the marriage. And so a lot of these expenses, it was established through evidence at the temporary order stage that these expenses were valid. And that, in the final order stage at the trial, it showed that, Mr. Knowles used these same types of things too. So just because these expenses were taken away at the final order stage doesn't mean that they're inappropriate at the temporary order stage. This absolutely is not like the Miss McPherson case. If you truly do have the bottom falling out of all the court's reasoning, in that case, we have the court saying, okay, husband, lost his job, and therefore the court said he thought that he was voluntarily underemployed. And then at trial, the court said, no, he just lost his job. He might have voluntarily done things to make it so that he did lose his job, but he's not voluntarily underemployed. And so that changed the numbers that the court used for the husband's income. But this court noted that, here there's no argument that Ms. Knowles was not spending money on chiropractors. She testified to that in trial. And then there's that binder full of evidence that was presented at the temporary order stage that she wasn't spending money on vitamins or childcare or therapeutic massages. All of that was money that was spent during the marriage. Yes, Judge Hagan.
So I would like you to respond. There's this statement in the reply brief that I know you haven't had an opportunity to respond to yet. And it says, it's on the first page, the court determined that wife had grossly inflated her expenses and understated her earning potential I assume with respect to the temporary alimony. Was there actually a finding that the wife at the time of the temporary alimony did not have those expenses or had understated her earning potential? Or did the court just reach a different result at trial?
So the court just reached a different result at trial. I'm not aware of a finding that says specifically that. Of course, we have in the income stage, the court does make findings about how Ms. Knowles was voluntarily underemployed. And it says in page 1345 that times and circumstances have changed since the temporary orders award, and therefore she is voluntarily underemployed. She can make more. Instead of being imputed at $1,200 a month, she should be imputed at about $1,800 a month. And then when we get to the needs analysis, the court certainly did not appreciate some of the evidence that was put on by both parties. It said it was basically they threw a bunch of stuff at the wall and expected the court to figure it out. And the court did say that some of the evidence supporting the expenses are lacking remote in time and remote in detail, and that's on page 1347. But then the court goes, and what's interesting is that Mr. Knowles hired a forensic accountant, and that forensic accountant testified that Ms. Knowles' reasonable monthly expenses were $4,700, but he didn't account in there an extra $1,000 for a rent or mortgage. Ultimately, the court awarded Ms. Knowles $5,300. It's right in the range that Mr. Knowles' forensic accountant said was appropriate for Ms. Knowles. And so all of these numbers, they're all supported by the evidence. They're all within the range that was testified to by Ms. Knowles and by the forensic accountant, and that were in the documents of trial. Just quickly to this, the last thing that Mr. Knowles talks about when it comes to the temporary award was this triple awarded medical expenses. I just wanted to be a little bit clear on that. So Exhibit 72 is okay. So at the temporary order stage, the court ordered the parties to split the HSA and to equally pay medical expenses. And so Mr. Knowles had to pay 50%, Ms. Knowles had to pay 50%. She just had to inform him within a certain amount of time, and then he was required to pay half. And so in this case, she submitted an Exhibit 72, which shows in 2018 that she informed him of the medical expenses that were incurred, and he failed to pay half. And so the court, Mr. Knowles didn't dispute this at trial, and so the court awarded that $1,900, I believe, or excuse me, $1,100 because of that unpaid half. I am unclear how that is considered double or triple paid. Mr. Knowles was required under the order to pay half of the medical expenses. And so was Ms. Knowles. She was also awarded, half of the HSA. So it was completely appropriate for her to, take whatever half she had to pay and pull that out of the HSA. But still, Mr. Knowles was still required to pay his half. So I'm not seeing how that is a double or triple or any additional award. It's just a straight up application of the temporary orders. Moving quickly on to the tithing and tithing being part of the marriage. Yes, Judge Harris.
Before you do, Ms. Adams, can you briefly respond to Ms. Nelson's response to my question about preservation? She gave us a slew of record sites there in which she indicated that not only the issue but the legal theory now raised on appeal was in fact raised in front of the trial court. And can you give us your thoughts on that response?
Mm-hmm. Your Honor, certainly they talked at length at trial about how Ms. Knowles was voluntarily underemployed, how she was dissipating the marital she was basically, the big thing in trial is that she had dissipated the marital estate. And so I do think that the theory at trial and all throughout trial is different than the theory that is raised up here on appeal. We went through in our brief, I believe on pages 17 and 18, and we go through and talk about what theories were actually raised. But I mean, it's always Ms. Knowles is intentionally dissipating the marital estate by not working and by overspending. And that's not the argument that's being raised here on appeal. On appeal, the argument that's being raised is that because we have final orders and they're slightly different than temporary orders, and there's got to be a problem. There's got to be a problem somewhere. There isn't an argument about intentional dissipation of the marital estate. And that was the constant theme throughout all of the trial. On page 1043 and 2164 and 2101. I mean, they're all cited in our brief, but it was always about intentional dissipation of the marital estate because Ms. Knowles refused to work, according to Mr. Knowles, and because of just overspending. Just briefly turning to the tithing issue, this is a really interesting issue. And it's fascinating that there really isn't a lot of case law here. But when we look at the rule case, what's interesting is the problem with that rule, with what happened, what the court did in rule, it shows up in paragraph 24 that Ms. Nelson was reading from. And in that case, it said the district court did not begin its alimony determination with the traditional analysis of the wife's needs based on the marital standard of living. Rather, the court determined the wife's needs in the first instance based on the straitened circumstances in which she found herself as a result of the divorce. Now, in this case, when we look at the district court's order, we have the court looking at the needs analysis, and the court does say in its tithing religious exemption discussion, which is on page 1346 to 1347, the court does talk about the party's straitened circumstances, but more than that, the court this is the phrase that I think that matters. The court specifically makes a finding that tithing is a donation and not a necessary living expense. And as Judge Harris pointed out, the statute specifically says needs. I think it is appropriate for the court to go through and see, what are the needs here? Yes, Judge Harris.
How far does that go, right? I mean, the statute does say needs, but do trial courts and by extension us, are we in the business of second guessing a family's financial choices in terms of what they choose to spend money on? I mean, Ms. Nelson's referenced the minor case several times today because she was involved in that case, but in that case, the trial court, among other things, determined that it was necessary for the wife in that case to have $5,000 a month for horse expenses. Now that's an expense that probably none of us sitting here would think was an expense we'd spend our money on, right? But is there some sort of judgment? Do we get to say, you know what, spending $5,000 a month on horse expenses is just silly, and we don't think that's a need. Nobody needs horses, right? So we're going to disallow that expense because it's not a need. I mean, it seems like the implications of your argument would sort of lead to that sort of analysis, and that analysis kind of troubles me. And I guess I wonder what your thoughts are on that.
Yes. Well, I think, Your Honor, what it comes down to is that in the financial declaration, the tithing was listed for both parties under the donations category. And from what I understand, it's actually, when things are donations, it's something that is voluntary. And so it's something that is, the parties get to decide whether they want to pay that or not. And I think it is completely appropriate for a court, and when it's determining the parties' needs, to take out donations. It's not, truly the minor case was exceptional because I do believe that the husband in that case it was like $75,000 a month for gross income. And here we are talking about $9,000 a month. So it's a very different analysis. But when we have donations, they're voluntary things. It's not food, it's not clothing, it's not education, it's not rent, it's donations. And when courts are going through and looking at these financial declarations and they come to the donation line, I think it is completely within their discretion to say, you know what, I'm not going to put that into a needs analysis because donations are voluntary. Donations are voluntary. And it's just not something that is necessary or
any expense is voluntary, right? Horse expenses are voluntary, right? You don't have to have horses. It's not like food, right? I mean, Ms. Nelson's point is, we can't really boil this down to just food, shelter, and clothing, right? I mean, that's not really what this is about. We look at the standard of living and what did these folks spend their money on, and we don't really, as I understand it, we don't really worry about whether the expense is voluntary or not, do we?
Well, I think that when the thing is that when these things are listed on the donation line of the financial declaration, they are voluntary, and it's not within the it is within the district court's discretion to look at that and to say, you know what, I'm not going to put this in the needs analysis. Like, you know, if I donate $10,000 to my kid's school, I'm not going to put that into the needs analysis. And I think especially here, and I think Judge Hagan was the one that pointed it out, so that especially here where we have a significant prejudice problem, where the tithing was taken out, was claimed by both parties in their financial declarations. The district court removed it for both parties. So nobody gets to claim tithing. This isn't an issue where one party gets to claim it and the other party doesn't. So essentially everything comes out basically the same. Because by taking tithing out, that means that her needs go down and his ability to pay changes a little bit, but it's all equalized up over time. And this is a case where the money was tight. I mean, the forensic accountant noted on the record that there just wasn't enough money to go around. So it was completely appropriate for this court to say, you know what, I'm not going to count tithing. I'm going to look at all the other expenses, and I'm going to reduce some of them based on the evidence that was produced at trial. And I'm just not going to count tithing in the analysis. It's just completely within the district court's discretion to do that, especially in this case where we just don't have enough money. $9,000 a month is fantastic for one household. It is much, much trickier when you're trying to support two separate households on that. And that's what the court recognized, and the court made an appropriate ruling when it was dividing up all of when it was looking at the parties' needs. Yes, Judge Hagan.
Judge Forrester, did you have a question first? I didn't want to jump in before you. Sorry.
Well, I was just going to say that the court did acknowledge, and Mr. Knowles did testify at trial that this donation was necessary in his life, that he considered it as part of his living obligation to his church. I mean, so who gets to decide what's important to one party and what's not? And I guess I just, it's more of a comment that I am emphasizing what Judge Harris asked, is that who's in the position to judge what is critical to one's needs? I mean, does it only depend on if there's not enough money to go around, that we have to be more judgmental, that the district court has to be more judgmental when there's not enough money to go around?
Mm-hmm. Yeah, I think it's an excellent question. The thing is, the statute plainly puts on the court the decision to decide needs and the ability to pay. So the court is placed by law in the position to judge and to determine what everybody's needs are. Does that make it complicated at times? It absolutely does. But here in this case, there just wasn't an abuse of discretion. We do not have enough money to go around. And so the court did the best it could, and it determined that Mr. Knowles' needs were $5,800 and Ms. Knowles' needs were $5,300. And then it crafted alimony off of that. And the thing is, I think what's lost in all of these numbers and all the mumbo jumbo that Mr. Knowles, well, I shouldn't say mumbo jumbo, but all the numbers that Mr. Knowles is throwing out, is that really the difference in alimony was like $39. And so even though there's a lot of talk about how much income and how much expenses and all of this stuff, in the end, the difference was from the final order to the temporary order was $39. It basically stayed the same. And the court notes in its order specifically that it tried to keep the expenses very similar between the two parties. So the court did its job here. Yes.
Except it didn't stay the same because she had the additional expenses of a mortgage payment and health insurance premiums. So that she didn't have during the temporary period. So, I mean, I can certainly see the argument that changed. But the question I wanted to ask you was actually similar to what you've already been asked about who makes the judgment. I mean, isn't the reason why we have this process where we look at the standard of living and we look at how much the parties were spending and we start with that number? And then if there's not enough money to go around, we reduce it proportionally. Isn't the entire purpose of that so that courts don't have to make these kinds of judgments about what's necessary and what's not, because different people are going to see it differently? And even if, and I question this, even if the court could, in general, say, I'm not going to consider donations as part of needs, do we have a separate problem here when the donation is part of a religious obligation? does that impact this idea of whether it's a necessity?
So as to your question about the religious obligation, I point the court to, I believe, so there's two cases that we cited on page 38 of our brief. One is Wright v. Wright and one is Harlow v. Harlow. And both of those cases exclude, and I believe it's Wright v. Wright, it's a Delaware Supreme Court 2012 case. And in that case, the Delaware Supreme Court upheld a district court's decision to not include tithing as part of the needs analysis in an alimony determination. And the court specifically said, and I don't know if this is where you're going with this, Judge Hagan, but the court specifically analyzed the religious piece of it. By excluding tithing, was there a problem with the free exercise of religion? And the court concluded that it did not. And so because the court's order did not prevent the parties from paying tithing, it just, in fact, the court just took that out, and then the parties could just do what they wanted with the money that they had left. And so anyway, point the court to Wright v. Wright, because that might answer the religious part of that question. But as for the other things about, the thing is, the statute does say needs. And so I think that definitely gives the court the power to look at these financial declarations, which sometimes can be inflated, and to say, you know what, I don't think this is a need. I think this is too much. I think this is too much. And so the courts are empowered to do that. And this court's job is to look at the court's order and say, did the court abuse its discretion in doing this? And I think the answer here very clearly is no. I mean, like we've talked about before, there just simply wasn't enough money to go around. In the end, the court awarded more, said that the husband, that Mr. Knowles had more, $5,800 in needs every month, whereas Ms. Knowles had $53. The alimony didn't change that much, only by $39. So when we're looking at, the whole crux of this case, the whole lifetime of the case, it doesn't seem like there's an abuse of discretion here. The court was well within its discretion. Yes.
One last really quick question for you, at least for me. Let's assume that we find that the court didn't follow the proper procedure here, that the court just had to look at what the standard of living was and then reduce it proportionally if there wasn't enough money to go around. The question in my mind then becomes, was this a harmful error? And you point out that both parties had claimed this expense and it was disallowed from both, which presumably lowered her expenses and also lowered or increased his ability to pay. But what is your response to Ms. Nelson's argument that it's not a wash because they both had different amounts? She only had about $500 and something, and I believe he had $1,100. Can you respond to that?
Yes. And then I think that at that point we start looking at, is this truly a line by line item thing? Do we need to be going line by line by line to making sure that everything is absolutely correct? And in this case, it just wasn't. If we look at the full order that the court issued and all of its reasons, in the end, and if you look at what the parties' amounts and their needs and the alimony and the child support, it just doesn't seem like we have an abuse of discretion here. It's well within the district court's discretion to award the alimony and to choose the needs that it did here. They just are so incredibly similar. And I just can't emphasize again that Mr. Knowles, his needs were listed at $5,800. So his needs are higher than hers. And even though they share child-rearing responsibilities, his needs are considered higher than hers. And so I just don't see how, if this case were to go back to the district court, how there would be any different decision. Because, the court did look at all of these expenses very, very carefully, looked at all the evidence the parties gave them, and reached a very appropriate decision about how much the needs were and then what Mr. Knowles was required to pay. Unless the court has any other questions, I ask that the court affirm.
Thank you, Ms. Adams. Ms. Nelson?
Thank you. I think that the discussion that we've just heard about needs is very important, very relevant, and we do not have a system in this state where we go down and say, well, it's okay if you donate to the Humane Society, but it's not okay if you donate to your church. And we also don't have a system where we say, well, it's okay if you have horses, but it's not okay if you donate to your church. And I don't think we want the law to start heading that direction. Divorce trials would get a lot uglier. And we certainly don't want to have a religious breakout here. That doesn't make sense. As to the harmless point, Judge Hagan's exactly right that the amounts were different. We see that in the commissioner's order at 289. That's a really easy place to see the difference. And the trial court is going to need to redo the math, and I don't know exactly how much it's going to change. As I said, Celia didn't cross appeal it, but it's up to the trial court to sort out what has happened there. On the temporary orders, I don't disagree that dissipation was a theory that was advanced at trial, but we have not advanced on appeal. But it was not the only theory that we advanced. All along, we advanced the theory that Celia was underemployed. That's why we had to have a vocational expert come in and show that. Because, we tried to say that at the temporary order phase and they didn't believe it. It wasn't until we got a trial that the trial court agreed. And in pages 9 to 10 of our reply brief, we will really walk through the timeline of what happened and of what the trial court said, rejecting all her theories for why she couldn't earn more money and just said, yeah, you can. Yeah, you can. And the expenses, there was a discussion here about her expenses being, Ms. Adams said that the parties did pay vitamins, even though the trial court knocked it out. But the trial court knocked it out, interestingly, not because it thought the vitamins were unnecessary, but because it felt like her expenses were lacking, remote, and artificial. So it makes these findings, and it never said, but the vitamin expenses were reasonable during the temporary orders, but now they're not. It just said, okay, now that I've looked at the evidence, I can see there's not actually enough evidence to support that. So in that way, I think the case is like McPherson. We have had the bottom fallout of some of these expenses, not the entire alimony award, but at addendum E of our reply brief, we show exactly where the bottom fell out of these individual expenses. And there was no explanation that they were okay at the temporary order phase. They were supported at the temporary order phase. Now we're just saying, okay, you got it wrong. Fine. Let's fix it so that these parties can move forward with their equal lives. There are a number of other issues in the brief, the orthodontia, et cetera, but I probably won't launch into them now unless you have questions about it. Otherwise, we will submit on the briefs. Thank you.
Thank you very much, counsel. Clearly, we had a lot of questions and your arguments and briefs were incredibly helpful. So thank you. Thank you so much. We will take this matter under advisement and render a written decision as soon as we can. And I'm so glad, Ms. Nelson, that you are, I don't know, at least feeling better. So
I'm sore, but on the mend. Thank you.
Good. With that, we will be in recess. Thank you very much.
Thank you.